The Supreme Court has reiterated that a blank check leaf, which has been voluntarily signed by the drawer and handed over to the payee towards some payment, will carry the presumption that it was issued in discharge of a legally enforceable debt as per Section 139 of the Negotiable Instruments Act. Even if a blank check leaf is voluntarily signed and handed over by the accused towards some payment would attract the presumption under Section 139 of the Act, and in the absence of any cogent evidence to show that the check was not issued in discharge of the debt, the presumption would hold good, the court observed, relying on the judgment in Bir Singh v. Mukesh Kumar, 2019. Reversing the High Court's finding which allowed the application of the accused drawer to seek a forensic opinion on the signature made on the blank check, the bench comprising Justices B.V. Nagratana and A.G. Masih, relying on the judgment of Bir Singh v. Mukesh Kumar, observed that once a blank check is issued towards the discharge of some payment, then a presumption regarding its validity would arise against the accused. It is for the accused to displace the said presumption. In Bir Singh, the Supreme Court observed that even if a blank check leaf is voluntarily signed and handed over by the accused towards some payment, then the presumption under Section 139 of the NI Act would attract, and in the absence of any cogent evidence to show that the check was not issued in discharge of the debt, the presumption would hold good against the accused drawer. A meaningful reading of the provisions of the Negotiable Instruments Act, including, in particular, Sections 20, 87 and 139, makes it amply clear that the person who signs a check and makes it over to the payee remains liable unless he adduces evidence to rebut the presumption that the check had been issued for payment of a debt or in the discharge of a liability. It is immaterial that the check may have been filled in by any person other than the drawer, if the check is duly signed by the drawer. If the check is otherwise valid, the penal provisions of Section 138 would be attracted. The Supreme Court observed in Bir Singh. Even a blank check leaf, voluntarily signed and handed over by the accused, which is towards some payment, would attract presumption under Section 139 of the Negotiable Instruments Act, in the absence of any cogent evidence to show that the check was not issued in discharge of a debt. The Supreme Court added in Bir Singh. Accordingly, the Supreme Court allowed the appeal preferred by the appellant drawer of the check and thereby set aside the impugned order passed by the High Court. Background. In the instant case, it was not in dispute that the accused has signed the check. The only dispute is about the age of the accused in making the signature on the check and the age of the signature and contents of the check. The accused drawer sought a forensic opinion to compare the contents of the check with the signature of the payee. The trial court rejected the application for expert evidence. However, the High Court has allowed the application, directing the trial court to send the checks for forensic opinion to compare the contents of the check with the signature of the appellant drawer. It is against the impugned order of the High Court that the drawer of the check has preferred the criminal appeal before the Supreme Court. Case details: K. Ramesh vs. K. Kodandraman, Criminal Appeal Number 000763, 2024. Citation: 2024 Live Law, SC. 145. Click here to read the judgment.